Hello and welcome to Social Media Law and Ethics. One of the first things that I'd like you to do as we get started is look at a couple of links. The first one here on the screen is from a Pinterest user site, and it's basically a social media law infographic timeline that will give you a sense of how we've evolved over the last few years from a social media law standpoint. The second link I'd like you to look at is a YouTube video from a friend of mine named Chip Stewart, who is a media law professor at Texas Christian University. And this is an interview that he did after a civic speaking engagement about social media law. So if you'll take a few moments to look at both of those links. The second link with Dr. Stewart, basically it sort of outlines the areas of law that are implicated here. So if you'll watch the video, he notes that, it's the same areas of law that many of us are interested in from a media standpoint. They're just translated into an online context. So we still have to be concerned about things like libel, copyright, advertising, privacy, antitrust laws, labor and employment, intellectual property. All of those areas are still concerns in an online context. It's good to have some ground rules at your organization, some policies, otherwise you leave things open to interpretation. And then finally he notes that in crisis situations it's good to get clearance for your posts, to have reviewers in place so that you're not putting your organization in jeopardy from a legal standpoint. The thing is, there is no defined law of social media yet. When we have a new media, such as social media, law typically evolves very slowly through cases, and right now it's just not able to keep pace with all of the technological change that's happening so rapidly. So a lot of times what we'll do is we'll take the old settled principles of law and try to apply them to new media. Some of the principles work, some of them don't work so well. So we're still kind of feeling our way around to see how things need to play out. Some of the unique aspects of social networking make the application of some of these laws a little bit more problematic. The one-to-many public communications. So this makes it very complex. So progress is in fits and starts, usually by litigation. So for an example of a case that started with Twitter in 2009, St. Louis Cardinals manager at that point, Tony La Russa, sued Twitter claiming that somebody posed as him, created a Tony La Russa page which made light of his drunken driving conviction, and two Cardinals pitchers who had died. So La Russa's complaint alleged that a fake Twitter page constituted trademark infringement and dilution, as well as cyber squatting and misappropriation of name and likeness. So that's a lot of claims for a fake Twitter page. Twitter ended up removing the account, and the two parties settled for an undisclosed amount. And that's what happens with a lot of these cases, is because the law is so uncertain, and because cases have the potential to drag out for a very long time, costing lots of money, people tend to end up settling a lot of these cases. So that doesn't give the courts much of an opportunity to provide any principles for us to follow. One of the major questions out there is who owns the content? Who owns user-generated content? There's that saying that possession is 90% of the law. In a blog post that responded to Facebook's revised terms of service, Mark Zuckerberg basically fell short of apologizing for all the changes that confused a lot of people greatly. But he used the opportunity to explain why Facebook more or less keeps your content indefinitely. He said this: when a person shares information on Facebook, they first need to grant Facebook a license to use that information so that we can show it to the other people they've asked us to share it with. Without this license, we couldn't help people share that information. So this is true. Without making this part of the terms of service, someone could technically claim they didn't know that anyone would see their status updates, as silly as that may sound. Continuing on, Zuckerberg then explains why the site keeps the content forever. He says when a person shares something like a message with a friend, 2 copies of that information are created, one in the person's sent messages box and the other in the friend's inbox. Even if the person deactivates their account, their friend still has a copy of that message. We think this is the right way for Facebook to work, and it is consistent with how other services like email work. So, lots of different conclusions on trademark, copyright, patents. There really is no present consensus on what's protected, what's public domain, and what's between, for example, and what is in between. And Facebook's Terms of Service crisis in 2009 was a very good example of that. The nature of the expression and the nature of the posting are both going to be key factors in deciding a lot of the legal cases and who owns what. Now, employers may use social media for hiring and firing decisions, as they did in this particular situation with Domino's Pizza. So if you want to see something rather shocking, a little bit on the disgusting side, here is a link to a YouTube story about Domino's Pizza employees who decided that they would show themselves making pizza and other Domino's products in perhaps the most lewd and disgusting way possible, and then the fallout from that. It's really crucially important for all organizations today to have a social media policy. Corporate social media policy can do a couple of different things. It can either really help people understand what's appropriate in a social media context, or it can prohibit employee participation. So companies need to realize people are talking about them on social media, whether they like it or not. So they need to try to do whatever they can to help guide those conversations. They need to be upfront with employees regarding how much privacy their employees can expect when it comes to what they post about the company on Facebook. And then existing company policies, they're already there, just extend those to Facebook. It's the same kind of conduct. You don't want sexual harassment in the workplace. You don't want it online either when it comes to your organization. So you might think about an employee code of conduct for online communications, a blogging policy, a comment policy, personal social networking policies. There needs to be clarity out there to ensure that your brand is enhanced and not damaged by an errant remark. We've had some good examples on how not to go about writing social media policies, Viacom being one. Viacom is an enormous corporation, and they released this statement that you see on the slide here as part of their new business practices statement in the summer of 2010. It was meant to ensure that all the employees of their subsidiaries like MTV, BET, and Paramount Pictures uphold the highest standards of ethical behavior. It was rather surprising for a media company to show such disdain for anything media-related and denoting individual expression. So here it is. You're discouraged from publicly discussing work-related matters, whether constituting confidential information or not, outside of appropriate work channels, including online, in chat rooms, on websites, or in blogs. You could tell this was definitely drafted by lawyers who do their best to avoid risk and have a lack of trust in employees. Legal folks usually don't understand social media and what it can do, and tend to respond by slapping controls on wherever they can. So if a company trusts its employees and understands that social media can be a very powerful way to do business, then it's the lawyer's job to create an environment where you can do what you know is right. So create guidelines that you can operate under. Include advice on how to communicate in any medium. Rather than putting restrictions on social media, focus on guiding people in the right way to behave. Some suggested content for social media policies. You want to definitely be transparent and always state where you work. You never want there to be any question about that. Never misrepresent or mislead your audience. Post meaningful and respectful comments. Disrespectful comments can definitely reflect poorly on your employer. Ask permission to publish content that is not yours. Provide unique perspective on non-confidential information. And if you're writing about your competition, try to do so with some class and be very diplomatic about it. Never comment on legal matters or litigation that's currently underway. Don't get involved in social media when it may be a crisis situation and you don't have the authority to do that. If you're not the PR director or the main spokesperson, just leave that to them. That's their job. Don't muddy the waters. When you disagree with other people, it's okay if it's healthy, if it's appropriate, if it's polite. What you don't want to do is descend into the realm of insult. That becomes counterproductive and damages your brand. Don't pick fights and be the first one to correct your own mistakes. Don't let somebody else call you out on it. You do it first. One additional consideration to think about. The National Labor Relations Board has recently taken some pretty proactive action when it comes to employees being fired because of what they've posted on social media, especially when those employees are talking about things like their working conditions, their salaries, their working hours. Those are things that typically are considered protected speech. It's still a very unsettled area legally. In the absence of case law, employers are going to have to be very careful in trying to protect the company on the one hand and preserving employees' rights to talk about their places of work on the other. So there is no general privacy law per se in an online context, but there is certain sector-specific legislation. So HIPAA, for example, tries to protect all of our healthcare information. Rick Boucher and Cliff Stearns, two representatives, a Republican and a Democrat, tried to push through a privacy bill in 2010 that was supposed to protect consumer privacy by requiring companies to disclose all of their privacy practices, to provide details on how they collect and use our private information, and provide some parameters around how they use sort of sensitive information. It also established how and when that information could be shared with third parties. Now, the bill didn't make it through the House. Senators McCain and Kerry tried to get something similar through the Senate. It also did not get through, but I have to believe that this is a huge, growing, dynamic area right now, and we're going to see more of these kinds of bills probably coming up because privacy has gotten to be such a huge issue. Think about the location-based services like Foursquare, where you can check in and tell people where you are. Well, there is a lot of risk out there when you engage in those kinds of services. Some people say it increases the risk of stalking, of letting stalkers know where you are, domestic violence issues. There's actually a site out there called, I think it's called pleaserobme.com, that kind of makes fun of these kinds of services because you're basically telling people who want to steal your stuff that you're out of your house and it's a good time to go rob. I mentioned in the lecture about blogging, endorsements and testimonials. The Federal Trade Commission acted in 2009 to make sure that people were being very transparent about the fact that they were being paid either in products or services to blog about those products and services. So that change came about, and also they said, we don't like false advertising or misleading sales pitches in other contexts. We're also going to make sure that you're aware we don't tolerate that in an online context either. So marketers who receive money or in-kind payments have to disclose that relationship now. One of the first cases of this to come about was with Ann Taylor Loft in 2010. Ann Taylor Loft held an event in January 2010 to promote their summer collection, and the company invited bloggers to attend this special preview event, and those that posted about the event, posted a blog within 24 hours of that event, were then entered into this mystery gift card drawing with a value of between $50 and $500 for the card. The event and the unusual request for posts for the prize money received a little bit of media scrutiny and caught the attention of the FTC. They said, "We were concerned that bloggers who attended the preview failed to disclose that they received gifts for posting blog content about that event." So, according to the article that came out about this, the FTC actually decided not to take further action on Ann Taylor Loft because it was just one discrete single event. It was a very small number of bloggers who actually participated, and Ann Taylor then had agreed that they would revise their blogger outreach policy and make sure that people knew to disclose that kind of information. Now, not so lucky was a group called Legacy Learning Systems, who actually were fined by the FTC about $250,000 when they asked affiliates to write reviews posing as ordinary citizens. Again, not disclosing the relationship there got them into some big trouble. Other recent cases that maybe provide us with a little bit of an indication of where things are going here. Food and Drug Administration cited Novartis for Facebook content that did not give any of the required pharmaceutical warning side effects that you often hear and see in print ads for pharmaceutical companies and TV ads. They didn't do that on Facebook, so the FTC said, you know what? It's a new medium, but the same rules apply. So that case really illustrates that if you're a heavily regulated industry, those regulations are likely to translate in an online context. Again, the National Labor Relations Board is going to be watching cases very closely to make sure employee speech is not being stifled too much. The New Jersey Supreme Court decided in a case called Stengart versus Loving Care Agency, which dealt with an employee who had an employer-issued laptop. And it was a home health agency that she worked for, and she was at a house taking care of a client, and then while she was there, she was checking her Yahoo email, and the emails that she was writing and responding to were from an attorney, and she and her attorney were actually corresponding about her employment at Loving Care Agency. Well, her employer actually hacked into those emails and tried to say, well, it was an employer-issued laptop. We had every right. Well, the court actually found for Ms. Stengart and said, you know what? That's attorney-client privilege. You did not have a right to read those emails or take any actions on those emails. May 2009, this is an even more disturbing case. Elizabeth Thrasher, she was a 40-year-old, posted the photo, the workplace email address, and cell phone number of a 17-year-old daughter of her ex-husband's girlfriend on Craigslist personal section. The 17-year-old was then harassed by men over the phone via emails and text messages. So Ms. Thrasher was jailed and charged with felony harassment. So again, just because it's in an online context doesn't mean that there aren't laws preventing that from happening or preventing punishment. Another case I wanted to highlight for you was Octavia Nasser. She worked at CNN from 1990 until her dismissal in 2010. Most recently, she had served as the senior editor for Arab Affairs at CNN. And in this capacity, she appeared on CNN to discuss breaking news in the Middle East and how it pertained to the U.S. and the world. Now, following the death of Mohammed Hussein Fadlallah on July 4th, 2010, she tweeted that same day that she was, quote, sad to hear of the passing of Sayed Mohammed Hussein Fadlallah, one of Hezbollah's giants I respect a lot. She was criticized for this perceived show of support for Hezbollah, which the U.S. government has designated as a terrorist organization. And she caught a lot of flack for that. And on July 7th, CNN fired Octavia Nasser. In an internal memo, CNN International's Senior Vice President, Parisa Khosravi, said, we believe that her credibility in her position as Senior Editor for Middle Eastern Affairs has been compromised going forward. There's another issue that's getting a little bit more attention from the FTC, and it's called like gating. It's where you promise something in exchange for a like on Facebook. There's also something called social media credential fraud, where you basically try to boost your social media metrics in a fraudulent way. You manipulate them so it looks like you're getting a lot of people liking your stuff. So maybe you make up a bunch of fake accounts and use those accounts to like your own, say, Facebook page. So it's probably just a matter of time before the Federal Trade Commission steps in and starts to create some regulations and enforcement policies regarding things like gating and social media credential fraud. Another area where social media is having an impact is in actual legal processes. Some attorneys are using Facebook profiles and Twitter to select a jury and to also cater their trial strategies based on what they find. So probably not much, I guess there's nothing illegal. Some could argue it's a little bit unethical to be doing this. Some bar associations, state bar associations, have actually authorized the practice of using social media to research your jury. At this point, the clear ethical line seems to be drawn where you're using social media in a fraudulent way. So maybe you're creating a fake profile in order to friend jurors or access information in somebody's private account. That is definitely something that bar associations would frown on. So it's a very dynamic, ever-changing area. We'll see in the next few years how things develop, but definitely an area to watch when it comes to social media.